anger from unions in Alberta today isn't just about legislating teachers back to work, it's about how.
What happened in Alberta today should terrify every worker in Canada.
It's almost as if you guys have actually never cared about our Charter of Rights and Freedoms, and you just use it as a talking point.
And this is wrong. Danielle Smith is wrong.
The government of Alberta invoked Section 33 of the Charter of Rights and Freedoms, the notwithstanding clause.
The notwithstanding clause is part of our Constitution.
We believe that this is a necessary measure to end the undue hardship caused by the teachers' strike.
To explain the controversial clause, let's go back to 1982. That's when the Queen signed the Canadian Charter of Rights and Freedoms. The provinces only agreed to the charter because it contained this. Section 33 says an act of Parliament or legislature may override certain rights for a period of 5 years. Expected to be rarely used, the notwithstanding clause essentially means provinces don't always cede all power to the courts.
So this is really my nerdy moment to shine.
Jeffrey Sigalet teaches constitutional law at the University of British Columbia.
Here we are at the University of Calgary Faculty of Law.
Turns out he was giving a talk about the notwithstanding clause at the University of Calgary Law School today of all days. He thinks the outrage is exaggerated.
Perhaps Alberta should cut the teachers a different deal. Perhaps not. Constitutionally, though, the sky is not falling.
He explains by including the clause in the legislation, the Alberta government prevents the teachers' union from taking the government to court, prolonging the strike.
It could have dragged things out, right? That's the bottom line. And that's part of what the Alberta government's calculation is in using a notwithstanding clause here.
Now, the charter doesn't specifically mention the right to strike, but a Supreme Court ruling a decade ago set precedent.
In its ruling, the Supreme Court says public sector workers have a right to strike as a necessary part of collective bargaining.
We will never, ever waver from our position that students remain in the class.
A couple of years ago, Ontario Premier Doug Ford attempted to use the notwithstanding clause to avoid a teacher's strike. But in that case, it backfired. Teachers walked off the job. And everyone ended up back at the bargaining table. University of Alberta political science professor Jared Wesley sees the Alberta situation as different, especially since the government limited debate on the legislation.
They're doing an end run around the constitutional norm.
He worries Albertans, relieved to have kids back in school, won't push back.
When governments, not just here in Alberta, but rest of the country, see that the public doesn't push back when the notwithstanding clause is used to solve a normal policy dispute, that becomes a tool in the policy toolkit of premiers across, and prime ministers for that matter, across the country.
Other provinces are using it. In 2019, Quebec invoked the clause to prevent public employees from wearing religious symbols. And in 2023, Saskatchewan used it for legislation about sex education in schools and notifying parents when students change their name or pronouns.
Once the notwithstanding clause becomes part of the policy toolkit, any government can use it. And that can apply to any right: freedom of expression, equality rights, due process. These are things that I think Canadians have come to take for granted since 1982.
Education's underfunded! So, was Alberta's legislation a standard move or a threat to fundamental rights? Like so much else, there's little agreement and much at stake.